Welcome to the South Carolina Probate Court. The purpose of this video is to provide you with a basic understanding of the probate court system and the process of estate administration in South Carolina. Probate court is a specialized court that oversees estate and trust administration, adult guardianship and conservatorships, marriage licenses, and mental health proceedings. In South Carolina, probate judges are unique because they are elected by the people in each county, and they serve 4-year terms. In South Carolina, each county has a separate probate court. Although the law is the same that governs all probate courts in South Carolina, there may be some specific procedures within each county. Before filing in your county probate court, please check to see what differences there may be. In addition, county probate courts sometimes provide forms and other information on their websites. Local judicial staff at your county probate court can help you navigate the website and assist you with these resources. However, please keep in mind that court officials and court clerks cannot give you legal advice or advise you on how to prepare legal documents. The law allows you to represent yourself in probate court. However, the laws and rules that govern probate courts can be complicated. Only an attorney can properly advise you of your legal rights, provide legal counsel, and act on your behalf. To protect your legal rights, you're strongly urged to consult an attorney. This video is not a substitute for legal or accounting advice. You should consult a local probate attorney in your county to help you with detailed questions. If you would like assistance finding a licensed probate attorney in your county, please contact the South Carolina Bar's Lawyer Referral Service at 1-800-868-2284.
Hi, my name is Mary Blunt. I'm a probate judge in South Carolina. We're going to now look at a video where we'll have a widow as she handles the death of her husband. Now, luckily, she will have the help of her lawyer. And together, they're going to prepare a specific form that the court calls an inventory and appraisement. Now, this inventory and appraisement form usually lists all of the probate and non-probate assets. As a simple explanation right now, you can think about assets as almost anything that the husband may have owned at his death. It can be a house, a car, a gun collection, bank accounts, even retirement accounts may be included. Now, this inventory and appraisement form requires that the value of most items at the date of husband's death be listed. Another way of looking at the form, and what we often tell folks that come into court, is that the inventory and appraisement form is a snapshot. It's a picture of the estate as it existed on the date of her husband's death. Now, please be aware that this form is filed with the court, becomes a part of the official estate file, and is public record. I'm going to turn now just for a moment to the issue of taxes. What you list on your inventory appraisement as the total value of the estate may later be important if you have a taxable estate. That's far beyond the scope of what we can cover today. So if you think you have tax issues, you're really encouraged to get a CPA or a specialized tax and probate attorney to help you with that. And please be aware that the probate court is not permitted to give any tax advice. Finally, and this is very important, please know that the probate court will never, ever send people to your home to value your estate, ask you about anything that you filed with the court, or anything to do with your finances. If anyone ever comes to your house posing as a representative of the probate court, you should immediately call your local law enforcement.
Well then, let's get started.
I brought the papers that you wanted me to bring, but I'm not sure I understand about this inventory and appraisement form. Some of the legal terms are confusing.
Well, that's okay, because a lot of this I can explain to you. We can work through the form slowly, and we'll go step by step.
Oh, thanks.
Okay? Now, you have a lot of stuff here, but first, I want to make certain that you understand the difference between probate and non-probate assets.
Okay.
Okay?
Sometimes folks don't know what's considered an asset, or specifically what we call a probate asset. Don't let this worry you. Your attorney will be able, and the court will be able to guide you through identifying assets. Again, remember, an asset can be a possession, a belonging, any item, even land that was in husband's name at the date of his death. Now, a probate asset refers to an asset that passes under the will, or if no will, through the laws of South Carolina. Different from a probate asset is something that is called a non-probate asset. A non-probate asset passes directly to a beneficiary without the probate court being involved. For example, think about your life insurance policy. That's actually a contract that you have made with the insurance company to pay a certain amount of money to somebody at your death. The insurance company will pay your beneficiary directly. The money will not go through the probate court. Another way of looking at that is that the transfer of these non-probate assets are controlled by terms of a contract or by law, but not by the will of the deceased husband. Some other examples that you might face in the estate that are non-probate assets are joint bank accounts, IRA accounts, and 401k accounts. Usually, both probate and non-probate assets must be listed and valued on the inventory and appraisement form. But each county has slightly different requirements for non-probate assets. So be sure to check with your local probate court.
So what's the difference between probate and non-probate assets?
Well, non-probate assets are simply assets that don't need to be probated, such as a joint bank account. Now, how are your accounts set up?
I'm not really sure.
Well, the deposit agreement with the bank determines how that asset will transfer, and you can use your certificate of appointment to find out.
Okay, I'll try to find out.
Now, your car may also be a non-probate asset. How is your car title?
Well, here's the title.
Now you see how the or here is between your name and your husband's name? This too is a non-probate asset, and in fact, I think it's the only other non-probate asset that we have here.
The inventory and appraisement form asks you to list all of the estate assets and their value on the date of the decedent's death, in this case, the husband. All probate and non-probate assets must be listed and valued. The inventory and appraisement form is a snapshot of the estate as it existed on the date of husband's death. Now, the personal representative wears the hat of a detective, and she's trying to find out all of the accounts and all of the other possessions that husband may have had. Once all of the assets are identified, the personal representative will determine the value of each asset. Now, the personal representative can get help with this in several ways. She can hire an appraiser, she can get estimates from real estate agents, she can look up values on the internet or through county sites, and she can use tax assessed values. Finally, if she doesn't have any other means of getting the information, just a good faith estimate as to what the value is fine. Now remember, the inventory and appraisement is a sworn document where you are promising the court that you're accurately reporting the assets to the best of your knowledge at that time. It's important not to overvalue or undervalue the property. And remember, this is important, if the personal representative later learns that there's information on the inventory and appraisement that's incorrect or incomplete, the form can be amended or supplemented. It's really not uncommon to have several amendments on the inventory and appraisement, as people discover items by going through paperwork, safe deposit boxes, and other things of the deceased. Now that we've discussed the inventory and appraisement form generally, let's look at the specific parts of the form. The inventory and appraisement form is divided into several distinct sections, and they're called schedules. We're going to now turn to the attorney in this video as he walks his client through each schedule in detail.
So let's begin to work our way through this inventory and appraisement form.
Oh, I'm glad you told me to get organized. This is a lot of stuff.
Yeah, and this is a very detailed form. And we have to file this inventory and appraisement form within 90 days from the date that you were appointed personal representative.
It's not a whole lot of time.
Well, don't worry, because we can work through this together, and if we need more time, we can always ask the judge for an extension. Okay?
Okay, I hope I have everything.
Well, let's begin with Schedule A, which includes real estate in this state and elsewhere. Okay? And let's begin with your home, and this appears to be your deed here. Okay. Now look, it looks that you and your husband were tenants in common. Okay, now what that means is that your husband owned a half and you owned a half. But at the end of the probate, we'll record that his interests passed on to you through a form called the deed of distribution. And at that point, you will become the sole owner of the home.
One of the most important possessions transferred is often land and a house, what we call real property. If that's the case, you should absolutely bring a copy of your deed to the real estate to your lawyer for him to review it very carefully. That's because there are several ways to own real estate. Your lawyer will figure that out from reading the deed. For example, the deceased, in this case the husband, may have owned the real estate just in husband's name, or the real estate may have been titled in the name of husband together with other person or even persons. Your attorney will look for what we call key legal phrases. We call it magic language. Things such as joint tenants with right of survivorship or tenants in common. Now, don't let these legal terms overwhelm you. That's why you have lawyers who are specially trained. They'll be able to review the deed, assess the deed, and determine exactly what you need to do to properly transfer it. Within the probate process, there's a deed of distribution. This is a legal document that's filed in the county where the real estate is located and where deeds are recorded. Now, the deed of distribution will show that the personal representative has released the right to use the property, has satisfied all claims on the estate, has listed the correct beneficiaries, and now those beneficiaries hold full and complete title to the property. Do not take shortcuts with real estate. It will cost you so much more money, time, and aggravation for your family later on. This is one place where you really need to just do it correctly the first time with the assistance of a probate or tax lawyer. I promise you it will save your family lots of headaches in the future.
Schedule A also includes any other types of real estate or real property, such as timeshares. Do you have anything like that?
Well, now that you mention it, we have a timeshare in Florida. I completely forgot.
No problem. What I can do is I can make a few calls and find out what the procedures are with the probate laws there.
Will it take a long time?
Well, usually not. If necessary, our probate courts here will prepare exemplified copies and we'll send it to Florida so that we can transfer the deed and close out the estate there.
Okay, that doesn't sound too bad. It will give me an excuse to go to Florida and visit family and maybe get a little Florida sun.
Okay, moving on. The next section is Schedule B. Schedule B asks us to list all of the stocks and bonds, but we need to determine the value of your husband's stocks at the time of his death. Do you have a quarterly statement?
Here's our recent statement right here.
Great. And I see the value right here. Sounds great. All right, great. So let's move on to Schedule C, okay? Now this is where we list your husband's checking, savings, or money market accounts. Anything that results in cash to the estate, okay? Now did your husband have anything like that?
No, we just had a couple of bank accounts.
Okay, okay. Well, great. You know, we can move on because I see you have the accounts listed here, all right? So let's move on to Schedule D. Now, Schedule D covers life insurance policies. Schedule D is divided up into two parts. Part 1 is where we list whether your husband had life insurance that paid directly to the estate, or if he named a beneficiary who is no longer living. And Part 2, we list any other life insurance that is paid to the beneficiary. Did John have life insurance, Louise?
No, he did not have a life insurance policy of any kind.
Okay, now on to Schedule E, which covers all jointly owned property. Now this is where we can list the car that you own jointly.
As mentioned earlier, assets owned jointly with right of survivorship are listed on Schedule E. Jointly owned property with a right of survivorship may include a joint checking account, stock accounts, or even a car. These non-probate assets pass directly to the named joint surviving owners. They are not controlled by the will. Now, some counties do not require you to list all these non-probate assets under the schedule, but some do. So be sure to check with your local probate court.
Now Schedule F is for personal property, like collectibles, baseball cards, tools, guns, anything like that?
Well, I did my best to list them all. He did collect a couple of things.
And this is a very thorough list. Are you ready to move on?
Yes.
All right. Great. Let's move on to Schedule G. Now, Schedule G concerns assets that transfer upon death, such as payable upon death accounts, savings bonds, trust.
Oh, we had nothing like that at all, just a simple estate.
All right. Well, let's move on. All right. Now, Schedule H is very specific, and it concerns something called powers of appointment, which is generally an asset that is connected to a taxable or a complicated estate. And this would have required some prior planning, so I don't believe you had anything like that.
No, you're right. We have a simple estate and didn't need anything like that.
Well, Louise, I know this is a lot, okay? But just bear with me. We're going to get through this, okay? So let's keep plugging. We're almost done. All right, Schedule I is for retirement accounts, 401ks, annuities. Wow, I see you have that taken care of. You did a great job listing the accounts here, Louise. Great
Yes,
job.
I think I have that one covered.
Yeah, great job. All right, finally, the last section is the encumbrance section, which includes things like outstanding mortgages or liens, but not general debt. Okay, now do you have any mortgages or liens?
No, we didn't have a mortgage. Now, we owned everything outright and usually paid cash for everything. Now, the only assets I have is half interest in the house and that old car to probate. And this seems like so much to do for such a simple estate.
Well, it's not as bad as it seems, and we're pretty much done with the inventory and appraisement form. But what I'd like to do is I'd like to go back through, and we want to make certain that we review all of our figures one last time, okay? And then we'll get you to sign this in front of my notary. All right?
Okay. Now, when we file this form with probate court, will I have to pay court fees? And if so, how much?
Well, state law sets the court fee based on the value of the probate inventory, but you'll be happy to know that you can pay them out of the estate account. Okay?
Well, and I also heard about a commission that I would receive for doing all this work as a personal representative. Is that true?
The personal representative, according to the laws of South Carolina, shall receive reasonable compensation for his or her work on the estate. but they may later waive this compensation. The minimum compensation is $50, no matter how small the estate. Now, reasonable compensation will not exceed, without the court approving it, 5% of the value of the personal property plus the sale proceeds of certain real estate. In addition, the personal representative may receive 5% of the earned income by the estate during the period of administration. Again, this is subject to court approval and based on appropriate and timely administration of duties. It's important to remember that any compensation earned is reportable as earned income on the personal representative's income taxes. Now finally, and most common, the personal representative is often reimbursed for certain out-of-pocket expenses as they're related to the process of probating the estate.
Well, do you have any additional questions, Louise?
Yes, I'm a little worried. What if someone says that my husband owed them money?
Well, creditors have a certain amount of time to file a claim against the estate. Now, that time started when we ran the notice in the newspaper, okay? Creditors will typically file a claim with the probate court and mail you a copy, but we've not received any claims yet.
Well, I don't think there are any creditors. But what if there are some and I don't have enough money or assets to pay the claims?
Well, when you can't pay all of the creditors, then state law will determine which creditors are paid first.
The personal representative has a duty to pay creditors their appropriate debts. South Carolina state law requires payment of creditors' claims on a priority basis. First, costs and expenses of administering the estate, and this does include attorney's fees and reasonable funeral fees, are paid first. Second, medical and hospital expenses associated with the last illness of the decedent are paid. Third in line, medical assistance paid from Medicaid. Fourth, debt and taxes that have preference under federal law must be paid. Next, debt and taxes with preference under state law must be paid. After that, the other claimants stand in line. Now, this is an area of the law that can change, so please make sure that you check this area. Keep in mind that secured debts, such as a mortgage on your residence, are not included in that priority list. Again, this may be an area where you want to have your attorney handle the creditors. They're trained to deal with creditors, they know which claims must be paid, and they know how to negotiate. This might be a good task to have a lawyer take off your to-do list.
Good thing I don't expect any creditor claims. Are we almost done?
We're finished with the inventory and appraisement form. We just need to complete the accounting form. And the accounting form shows what assets have been received and where those assets have gone. And we will complete that accounting form on our next meeting. Okay. Now, do you have any questions of me today?
No, I feel like we've used a microscope in class today. This form was very detailed. It's been a long time since I was a student.
Well, you know, you did a great job on your homework. We'll see you next time.
This video covered a lot of material. The inventory and appraisement form is a detailed document that provides the probate court with a snapshot of the estate at the time of your loved one's death. If you have questions about how to complete this form, how to value the estate's assets, or an estate tax issue, you're strongly encouraged to consult a local probate attorney in your area or visit your county probate court. Remember, only attorneys can provide legal advice.